So, is it expected or not? Well, what I in this matter, there's a direction to bring with the type copy of the FIR. What I am now type copy of the FIR. But one of the difficulty is that in the second application of the section 438 CRB. There is a no such change in circumstances, but there is an amicable settlement between the victim and the accused person. I know, that is although not a ground. 376, but
I have
actually
one,
there is a
one post statement which is translated. Lordship, it is an second application which has already been turned down on the first occasion, considering the merit. At this stage, how can we?
The end of the list.
Number three.
For the station.
This is a case under section 21C of the NDPS Act. Admittedly, I'm the owner of the vehicle. Nothing has been recovered from my possession. The allegation is that on the subsequent day,
What is the quantum?
My lord, 500
Bottle of
bottles
cough
of cough syrup.
Cough syrup.
Yes, my lord.
So commercial quantity.
Yes, my lord.
Commercial quantity.
Yes, my lord. Commercial.
but I'm the owner of the vehicle. Nothing has been recorded from my
From
possession.
his motorcycle, it was found. And
How
he
much?
paid 500 bottles of
On a motorcycle?
On
yes,
a motorcycle.
from a bag. He fled away from the spot, my lord.
In a broad daylight, kindly see, my lord. The allegation is that I came in a motorbike after seeing the police party. I make the U-turn, and at that time I fell down on the road, and my lord, thereafter I ran away.
This is the vehicle detail.
On a broad daylight, police person with his team, my lord, they could not apprehend me, my lord. In a broad daylight, when I am fell down by a from the motorbike, my lord.
Charge sheet not submitted, my lord.
My lord, I will cooperate in any condition, my lord.
This is the vehicle details, my lord.
My lord, I am a local resident, no antecedents against me, my lord. Not any condition, my lord.
There is also, my lord, independent witness statement of the independent witness also there. They saw that he fled away from the spot. This is the vehicle details, my lord.
Then, my lord, not any condition.
Yes. There is alleged recovery of commercial quantity
Item number O,
My lord, I am for the petition, I am praying for day after tomorrow.
Yes,
Monday.
as prayed by petitioners council, list on Monday.
number 5,
My lord, I am for the petition.
my lordship praying for possible lordship.
What happened?
My lord, type copy of that.
Court number 3 lordship.
Get him.
My lord, case under section 363, 365 and 34 of the Indian Penal Code. My lord, the petition number 1 is the mother of the principal accused. My lord, petition number 2 is the uncle of the principal accused, and my lord, petition number 3 is the father of the principal accused. My lord, admittedly, there is a love relationship between the principal accused and the victim girl. My lord, subsequently, they have been cleared away. And my lord, the present FIR had been lodged. My lord, till date,
Yes, have you seen the judgment?
Yesterday's matter, my lord, I don't want to trouble your lordship with other judgments, only one judgment I was.
No, that the.
Relying yesterday, my lord. Only
Yes.
one thing, my lord, I would like to bring the.
Yesterday, I had asked you to see until judgment.
I've seen.
It says if that
Yes,
41 notice is not given, then he is entitled to grant of
my
anticipation.
lord,
That is what the
but
judgment says.
specifically, my lord, this issue is, my lord, that has fallen down from the lordship, my lord. The issue is, my lord, does it, my lord, in a blanket manner, it becomes, my lord, infructuous or not, my lord? So I just.
No, we see if the apprehension arises,
Because, my lord, there is no warrant of arrest pending. There is no proclamation proceedings pending, my lord. And moreover, my lord, charge sheet has been filed, my lord. But the
So
IU has,
therefore
IU
there
has
is-
prayed for issuance of warrant of arrest. My lord. That is our only apprehension during surrender.
but
my lord.
now the IU has himself issued notice under 41. Where
That
is the
true, my lord,
question?
but still the apprehension is there because of this reason, my lord. I'll trouble your lordship with only one subsection of 41A, my lord.
Thirty-five, three.
Yes, my lord. The same is there. 35, yeah, 35.5, my lord. 33.5, my lord.
Yes, therefore I am saying if
33.5.
for reasons to be, once that reason is recorded, who will stop you?
So this says, my lord, when such person complies and continues to comply with the notice, he shall not be arrested in respect of the offence referred to in this notice, unless for reasons to be recorded, the police officer is of opinion that he ought to be arrested. This is the
What-
right, this is the only apprehension, my lord.
What is new? This is for everyone who is issued
This
notice
issue has
under.
to be addressed, my lord. If your lordship addresses it, my lord, this will
This-
become a very
this-
leading judgment, my lord.
Yeah, see,
Because
we are
this
concerned
vacuum, this
whether,
vacuum, my lord, is there.
whether there is any apprehension or not.
There is an
When you are appearing and when you are responding to the notice, if such a situation arises and he passes an order, then that has to be seen. It
Only
cannot be
apprehension
seen
is,
right.
my lord, he has prayed for.
This is something which applies to everyone who is issued notice under 40. This is nothing unique to you. This is nothing unique to you. This is a statutory provision
33(5), my lord.
that we have seen that that doesn't appear to be any cause for
Arrest.
That is a cause for
there's,
concern, my
there's
lord.
no
As per as
threat. There is no threat of arrest.
petitioner and similar.
After
effective-
41(3) has been issued, 31(3), 35(3),
35.
35(3).
This is a subsection of 35 only, my lord.
Yes.
33(5), my lord.
No, 35, not 33. It's 30.
35(3), right. Only cause for concern is 35(5).
That's nothing unique in your case.
Because, my lord, till 4 years, I was not aware this case was instituted. This complaint was lodged, my lord. Fortunately, my lord, his learned, his advocate was there in the court when the charge sheet was being filed, my lord. He came to know, and thereafter immediately this application has been filed, my lord. In the charge sheet, he has paid for warrant of arrest, my lord. And, my lord, the IO himself is saying, my lord, that the notice has not been issued in the charge sheet.
There is nothing unique. This is a statutory provision.
Or, my lord, let the state give an undertaking, my lord, that he will not be arrested, my lord.
Lordship, one
You
thing
see,
that-
yes. How can they give such a blanket, contrary to the statute, a blanket undertaking?
As far as this matter is concerned, my lord.
How can they do it? Opposing the statute. Against the statute, the court will ask them to give a undertaking.
So that's why, that is my apprehension. That's my fear.
Maybe your apprehension, but there is no threat. There is an apprehension that maybe other cases are also pending against you. Who
That
knows?
is only apprehension.
There is
Lordship,
no
one thing
apprehension.
must be noted, Lordship, yesterday they went to the, before the IO, they complied, Lordship, there was no arrest on me, Lordship.
Correct.
Because there was a protection, my lord.
Attend-
Till the end of
attendance
this
was there
circuit, there is a
in that
protection, my
Lordship.
lord. My lord, kindly see the interim order, last circuit, my lord. There was a protection till the last day of this circuit, my lord. So,
Therefore, you have not been arrested.
That's-
Otherwise, in spite of 41A, you would have been arrested.
my lord, he is a political person, my lord. Anything is possible, my lord.
For everybody, anything is possible. Nothing is
But-
special about you.
Yes,
Before the
that's
court,
true.
everyone
It's
is
absolutely true, my lord.
equal.
Yes, my lord.
Before the court, there is no distinction between you or anybody else. The statute remains the same for everyone. Once 41A has been issued, where is the question of doing? What was the last order? To issue a notice under
Last order
41?
was, my lord, there was to issue a notice within 7 days, my lord.
Yes.
It was issued after 13 days, and I was given 7 days time to respond, my lord. But on the same day, in course of the day only, he met the officer, my lord. It was complied, my lord.
So now this order has been complied with. In the last order, yes, take down. You were showing some earlier order that I have passed in some case.
Yes, my lord.
Let
Because
us-
that
let me
was,
see.
my lord, I give it to your lordship also.
You have given that.
Copy now.
We have it. I have it. Don't worry.
My lord. In this case, my lord, similar situation has arisen, my lord.
What are the allegations in this case?
My lord, allegation is, my lord, on 18th of August 2021, during a press conference, he made some provocative statements, my lord.
Oh,
With an intention to incite his supporters, my lord.
then it is not a very In a
But my
crime
lord,
also.
but my lord, he was not aware, my
No
lord.
apprehension was unfounded. Have you examined the issue with reference to 35(5)? You are making a submission without, have you examined it with that, reference to that provision? Because under 41 also there is a similar provision, like 35(5). Oh, come with some judgment on that issue. If you want to really argue that issue, you come with some judgment.
Monday, my lord.
Very well. You also examine it.
35.
Yes, he says that that threat still continues.
Empty
Must
block.
have been considered and dealt with in some judgment. Must have been.
There is one judgment of Karnataka High Court, my lord. I'll cite to your lordship on Monday, my
As
lord.
prayed by Leonard Counsel for the
After this
petitioner.
entry line, my lord,
List on Monday.
empty block. my lord. I'm grateful, my lord. I'm going to be.
May I, my lord?
Yes.
My lord, in page number 11 of my application, in the FIR, there is name of 6 accused persons, a vehicle which was seized by Moinaguri police station, and they recovered huge quantity of liquors, 92 cartons of Imperial Blue liquor recovered from that vehicle. My lord, there was a mark that for sale in Punjab only. So these 6 persons were arrested by the Moinaguri police station. Now these 6 persons revealed one name of Niranjan Rai, and another is Bula Adhikari, and police raided in the house of Niranjan Rai. Now, when police conducted raid in the dwelling house of Niranjan Rai, police found near about 15,000 liter of liquor, fake
Spurious
liquor,
drink.
spirit.
Furious one.
That's it, my lord. And said Niranjan Rai is still absconding. One Bula Adhikari is got arrested, and this case was handed over to the Excise department, and a CR case has been started against that 6 persons along with Niranjan Rai and that Bula Adhikari. Now,
CR case means what?
yes,
Complaint case.
complaint case.
In excise and forest wildlife matters, complaints.
Complaint case.
By the competent authority.
Yes.
Yes. Now, my lord, that go down, that dwelling house, all are belongs from Niranjan Rai and his wife Bula Adhikari. One power of attorney was there that actually land belongs from Udara Kanto Rai, son, father of the Niranjan Rai, who gave a power of attorney to Niranjan Rai, and Niranjan Rai running a business of these liquors in his house and adjacent go down. Now, to save their skin, said Bula Adhikari, wife of Niranjan Rai, my lord, kindly pay to peruse on the page number 15 of my application. Para
May I hand up the CD?
number 3.
Here is the agreement, my lord.
There is a agreement. Yes, my lord.
He was in possession of the
premises.
Yes, Allah, let
There
him
is a-
complete. Don't
Yes,
get impatient.
yes,
Yes,
ma'am.
yes,
To save their skin,
yes.
said Bula Adhikari shows one tenancy agreement paper between this present petitioner Bikash Orao and Niranjan Rai. And on the basis of said tenancy agreement, they are showing I am the owner of this entire, I am running a business in this entire adjacent godown and the premises. Now, my lord, said tenancy agreement was too old, and say tenancy agreement was made for storage of some phenyl and household articles, I think, my lord. Just to save their skin, Bula Adhikari shows that agreement, and I was booked in this case, my lord. And there is some sections, especially 46A clause C, which deals with imports, exports, transports, possesses of the sales.
You have the provisions with you.
Yes, my lord.
I'm carrying the book with me.
You have the book. 46A,
46A C.
C.
That section did not rely upon me.
46ACC.
Forty-six A plus C. I touch 46A plus C. I touch a 46 A, 5260.
So what is the basis for 46 capital double A?
It deals with 46 double A, some of the toxic death due to
Here, have a look.
46 double A. 46 double A does not attract. 6 double A.
Please point out from the FIR or how 46 double A has been.
No, death has not been caused.
No, read it, please. Please read aloud. Please read aloud.
Read loud, reading loud. Whoever mixes. Oh no. What I have difficulty reading. 75% gone. Hey. Wait a minute.
Whoever mixes or permits to mix with liquor or any intoxicating drug, any substance which is likely to cause
Likely
disability
to cause. Yes.
or death to human beings shall be punishable with imprisonment for life or imprisonment of either description for a term which may extend to 10 years and
So
fine.
what is the basis in the FIR for adding this 46 double capital A?
Why not?
Which is that portion of the FIR which,
May I get back to you?
yes.
It's but there.
Go through it properly, assess tomorrow.
No,
Yes, not today. You also examine it.
but I will come up with the ingredient of each section.
Yes.
Number 8.
My lord, I am praying for not to.
Yes, not today.
Item number 9.
My lord, I am for the petition.
My lordship, CD is not available, lordship.
Not today.
Not.
Item number 10.
I'm for the statement.
I am praying for a short Passover.
Not today. Next.
Item number 11.
My lord, I am for the petitioner, my lord. In this matter, my lord, this matter was adjourned for At least 4 times, my lord.
Lordship, we have not received the CD yet.
Switch it off.
Yes, call them.
Number one.
Lordship, in item number one, I'm for the respondent banks in this item number one. Lordship, if Lordship sees the last order, the Lordship paperwork was called for from the present appellant. And no such paperwork has been handed to me as of now, Your Lordships.
We're done.
Lordship, there was a direction for handing over the paperbook. No such paperbook has been handed over yet.
Yes. No, paper book has not been handed over.
No, Your Lordship.
These are all for. Keep the list. And what is can two for?
Can 2 is my application, Your Lordship. That was with regard to a leave given by this honorable bench regarding filing of one RTI document, which we obtained after the writ was disposed. And as the documents was to be put on the record, the Lordship has given me the leave to file an application with an affidavit regarding the said documents. And Your Lordship, on the last bench, the Lordship has had verbally said that the canto will be decided when the main application is been heard.
It is in the nature of an application for additional evidence.
Additional evidence.
Therefore, it has to be heard with the main appeal. None appears on behalf of the appellant. Stop. Matter to be listed on Monday.
Number two.
Not in every case, I don't think that, but we have to be application of limitation. Principle, nothing. There is a judgment of the apex court. Section 5 will not apply to this proceeding. Principle of the law matches it. Not limited. Same order, Monday. Come from Monday. No. That's what they are also taking this. Yeah. Again from 511.
ভিডিওটা এটা রাখুন হয়তো।
Call again. Call again.
Item number 3.
Same order. Monday.
Item number 4.
Have you seen the corridor?
No, sure. Item number 4. Then
Lordship, in 4, I am appearing on behalf of the Central Pollution Control Board. Respondent number 5, Lordship.
You were supposed to give us some judgments yesterday. You still haven't given the judgments.
Lord GP is there, Lordship, on real estate.
Lord, I was addressing your lordship.
Yes, he was expected to give us judgments yesterday. Nothing
sir.
has been.
Lord, the judgments I am told has been given.
That is not a correct information given to you.
Lord, my instructing advocate is with me. She's saying.
We are telling you, Mr. Bose.
No, I can. That's what I'm extremely
Yes.
sorry about this, Lord.
Now we are getting it.
I'm extremely sorry, Lord.
Yes. Anyway, which judgments? Let's see.
Lord, she will take the Calcutta weekly notes, 96 Calcutta weekly notes, page 278. Lord, this is a division bench judgment of the Calcutta High Court.
Yes.
Lord, which deals with two judgments of the Supreme Court. And my lord, in both these two judgments of the Supreme Court, one judgment says that they are both interpretation of section 19 of the Contempt of Court Act. Whether an appeal
Yes,
lies
give him the
Contempt
citation.
of Court Act.
You give him the citation, you need not give him the copy with the reported judgment, at least give him the citation.
Well, 96 Calcutta Weekly Notes, page 278.
No, your instructing counsel is here. He is giving him. Don't worry.
My.
He doesn't know. He doesn't know. Once he has handed over copies to us, he doesn't remember what is the judgment. Show him. Let him take down.
No, it is.
So it is referring to section 19.
My lord,
Orders
90,
are
right?
direction, orders and direction or directions for punishment of contempt. That is the expression.
Correct, my lord. My lord, this expression, my lord, this appeal shall lie as of right from any order or decision of the High Court in exercise of its jurisdiction to punish for
Punish
contempt.
for contempt. Yes.
My lord. So, my lord, the issue was whether there are two judgments. My lord, one is 1988 Supreme Court, which is the Tanejas case, where Supreme Court has held that unless there is an order for punishment, no appeal would lie under section 19 from a High Court single bench before an intra-court appeal before the division bench.
Yes.
My lord, what it does not take note of are two previous judgments of the Supreme Court of coordinate strength, which holds otherwise. So, my lord, this issue, when it came before the division bench of Calcutta High Court, my lord, which is the judgment which I wish to rely upon, which is 96 Calcutta Weekly Note, page 278. Well, I just show your lordship the relevant paragraphs. Well, kindly take first paragraph, well, paragraph 1. There, my lord, the issue has been, lordship will find, this appeal under section 19(1)(a) is directed against the order of the learned single judge of this court passed on a contempt application in such and such, wherein the learned single judge held the appellant guilty of contempt and directed him to purge the contempt by making redelivery of possession of certain property by a certain date. It was also indicated by the single judge that in the event of his failure to comply with the order, the court might be under a painful duty to confine the contemptor in civil prison. It is indeed a case of civil contempt. Now, my lord, kindly take paragraph 7.
Yes, so this is a judgment of the single judge in furtherance of punishment for contempt.
Yes, my lord.
This is
So,
not a proceeding where the contempt has been dropped. He is
No, my lord.
proceeding. Yes.
So
That
even, my
is
lord,
what
why-
it appears from paragraph 1, which you have read. Yes.
Correct. My lord, now, while interpreting 19, my lord,
Yeah.
even, my lord, the division bench of our court, my lord, has traveled considering the previous judgments of the Supreme Court has interpreted what is the scope of 19.
Yes.
My lord, allow me to place a few more paragraphs. Kindly take para 7 once.
Yes.
Let us now examine whether the impugned order is appealable under section 19(1)(a) of the Act. Although no punishment for contempt has been imposed on anybody by the said order. Then, my lord, 19 has been set out. Now, my lord, kindly take para 10.
Yes.
It has been argued on behalf of the respondents that the expression order or decision of the High Court in exercise of a jurisdiction to punish for contempt, as used under section 19(1), refers to imposition of any punishment prescribed for the contempt in section 12 of the exercise. Then, my lord, kindly take the last 3 sentences of para 10 at page 286. In this connection, last 4 sentences, my lord, last from the bottom of that page. In this connection, it may, however, be noticed that 19(1) does not say that an appeal. At that same page, my lord, page 10, para 10, page 286, last 4 lines from the bottom.
Yes.
In this connection, In this connection, it may, however, be noticed that section 19(1) does not say that an appeal lies only against punishment for contempt, but uses rather a wider expression that an appeal lies from any order or decision passed in exercise of jurisdiction to punish for contempt. The expression any order or decision in this connection purports to connote prima facie a variety of orders or decisions that may be passed by the court in exercise of its jurisdiction to punish for contempt. Then, my lord, kindly, my lord, take where paragraph 11 starts on that page about, my lord, 7 lines before that, there is a paragraph starting that the expression order or decision in subsection 1 of 19 also includes something other than punishment will appear from a reading of subsection 2A of 19, which provides that pending any appeal, the appellate court may order that the execution of the punishment or order appeal against be suspended. If no other order except punishment would have been appealable, there would have been no necessity of using the words or order in the expression, the execution of the punishment or order appealed against, as used in subsection 2A of 19. Well, thereafter, my lord, I'll trouble your lordship with paragraph 12 words. Paragraph 12 reads, my lord, we thus find that there are sufficient and persuasive indications in the provisions of the Act itself for coming to the conclusion that the ends of justice may be defeated in a good number of cases if the words and expression used in section 19 are not given their natural meaning, and if words like or order occurring in the expression execution of punishment or order appealed against are treated as redundant and surplusage, contrary to the established principle of interpretation that no order or expression used by the legislature should be taken as redundant or surplusage. To give a restrictive meaning to the provision of section 19, as desired by the respondents, will be tantamount to deleting some words and expression used by the legislature under section 19, which we are afraid cannot be done. Then, my lord, your lordship will kindly take paragraph 16, 1-6. My lord, para 16 takes into consideration, my lord, a previous judgment of the Supreme Court in the case of Baroda Kanto versus Odisha High Court. My lord, this is 76 Supreme Court. My lord, your lordship will can make a note. My lord, there were 2 of them. One is in 76 and the same cause title, there is one in 74. It has reference to both. So kindly take para 16 ones. It has been observed that only those orders or decisions in which some point is decided or finding is given in exercise of jurisdiction by the High Court to punish for contempt are appealable under section 19. But the order under consideration in the said case was not such an order or decision, it being an interlocutory order pertaining purely to the procedure of the court, and all that the order in question said was that the points arising in the case, including the one of maintainability of the proceeding, would be heard together. So, this decision of the Supreme Court, like its earlier decision in 1974 Supreme Court 2255, does not say that except punishment, no other order or decision appealable under section 19 is appealable under section 19. Then, my lords, if your lordship reads on, the sentence which starts thereafter, the distinction between the 2 Barodakanta cases, it may be noticed, is that in the former, well, on the other hand, it formulates the proposition that only those orders or decisions in which some point is decided or finding is given in the exercise of jurisdiction by the High Court to punish for contempt are appealable. So now, my lord, pausing here for a moment, your lordship will see the order passed, which is impugned before your lordship. The learned judge proceeds to interpret the affidavit of compliance and the subsequent order passed by the state and comes to a finding that this is my entitlement, so which in my respectful submission takes away a right of mine to challenge that subsequent proceeding, and in any event that itself was contrary to the previous order of the learned single judge,
There is
by
no,
which
is there any liberty to assail the order
no liberty,
in the contempt?
no liberty. So, my lord, what has happened is that order I cannot challenge because that order has been interpreted by the learned judge in contempt jurisdiction. So that affects my right because he has decided and taken a decision while exercising his contempt jurisdiction. My lord, kindly see the order once. It starts at page, the impugned order starts at page, my lord, 310. The relevant portion is at 316.
Please read para 23.
I stand corrected, my lord.
Please read para 23.
Para 23. Yes, my lord. 23. Yes, my lord. It is made clear that nothing in the order shall be deemed to be an adjudication on the merits of the contention raised in law and fact by the petitioners, and it will be open to the petitioners if aggrieved by the reasoned order passed by the alleged contender to challenge the same before the appropriate forum, writ code available to the petitioner in accordance with law,
Yes.
where all questions will be kept open. Well, yes, well, the liberty.
That is why we asked you whether there is any
Yes,
liberty.
yes, well, if I may just say this, well,
Yes.
the liberty is, but the finding which is already there in the contempt jurisdiction, that my entitlement, if I may just
There
try
is
your
no
lordship,
finding. The judge has made it clear that there is no finding. It is all open to challenge, nothing. There is
well,
nothing.
if I may just trouble your lordship with paragraph 13 once, 1-3 of the same judgment.
He may have said everything prior thereto, but he has made it clear in paragraph 23 that there is no finding and which can be considered as a finding in a matter when you bring it before the court challenging the decision. That is very clear and explicit in para 23, and that is why we asked you whether there is any liberty.
No, my lord, it was my mistake, my lord. It escaped my mind, my lord. Indeed, there is a liberty. Liberty in the sense, my lord, it is more in the nature of a, if your lordship will see the language, it is said, it is made clear that nothing
in this order, nothing in this order
shall be deemed to be an adjudication on the merits of the contention raised in law
and in fact
by the petitioner. It will be open to the petitioner if we agree by the reasoned order. So, my lord, if your lordship will kindly indicate then that, my lord, this para 13, 14, and 15.
Yes.
My lord, where it says the revised rates, although given effect to by virtue of the order, takes effect as per the order itself on and from 2023. This para 16.
Yes.
Based on the compliance report, the learned judge.
Yes.
My lord, it starts from paragraph 10 onwards. My lord, kindly take once para 10 onwards. It says that
Mr. Bose, are we required to examine all that in view of the clear and explicit paragraph 23? Its intention is clear and nobody can even think otherwise.
So then in that event, my lord, your lordship will kindly clarify that the finding, because this is more in the nature of findings, it is not even observations. If your lordship will see from para 10 onward, it considers the order of 30th June, by which the state says that my entitlement would be from June 1, 2023. The learned judge proceeds to examine this and comes to a finding at paragraph 16 that the revised rates would be given effect to, so far as I am concerned, from June 1, 2023. So this should not, but when I challenge, if I do.
As per the said order, it is not as per the court's finding. The revised rates, although given effect to by virtue of an order dated so and so, takes effect as per the said order on and from 1 June 23. This is not the court's finding. This is as per the order, it takes effect from such and such date. The court says no case is made out for contempt. I cannot travel beyond the order. There is a substantial compliance. Now, whether you get it from date A or B is an issue which you may pursue in an appropriate proceedings.
Lord, this, in my respectful submission, if your lordship will see, the order which was passed in the writ proceeding at page 294.
You have already read that. We have seen that order. We have seen that order. Yesterday, we have gone through the order.
Yes. Well, I'll just trouble your lordship with one paragraph at page 296.
Yes.
This is after the consideration paragraph. It says, upon such consideration, the current finalized tender rate shall be made applicable to the petitioners, if necessary, by modifying the contract with the petitioners and or novation of the contract on such terms.
As
So,
of
Willard,
now, where is the finding that their whatever they have done in purported compliance of the court's direction is correct?
I'm not on that, Willard. What I'm trying to say is that, Willard, here at this para at page 296, the court came to a specific conclusion.
Maybe,
on
maybe not.
consideration.
Maybe, maybe not. Are we to examine that issue here? Maybe, maybe not.
Yeah. Willard, I say that, Willard, that this is the order which was binding upon the respondent.
Who says
respondent-
no? Who has said no?
So, but the difficulty is that the contempt court said no. Willard,
The
contempt
contempt court said no case for contempt is made out.
Right.
Contempt court did not substantiate the order. It is very clear. The respondents are not in appeal against the order, even though it has been left open to be agitated in an appropriate proceedings.
So what I was respectfully submitting is, Willard, the direction which was there in the writ proceeding at page 296 specifically record that the finalized tender rates at the current finalized tender rate would be applicable to me, and I should be given that. Now, Willard, in the contempt jurisdiction, the judge records based on a subsequent discovery of rate that would be applicable to me and leaves it open to me to challenge it.
No, where is that decision that what is applicable to you now?
But
Where
if
is
I-
that decision in the contempt court's order that whatever they have done is correctly applicable upon, that is applicable upon you? In fact, the judge has said, I have considered things, but I am not pronouncing on the correctness of whatever has been done and whatever revised rates have been given. It is all open to be agitated in appropriate proceedings.
If I may just trouble your lordship once with para 9 of the order passed in the contempt jurisdiction. Allow me to, Willard, read it once for your
Yes.
lordship's consideration. Para 9. Now, this is after the 2023
Plausible,
order.
what is the meaning of plausible?
Well,
If
it says
you're
that
referring to paragraph 9,
Malad.
perhaps you will be referring to that plausible.
I would, Malad, I would.
Then
It was a
plausible means
view that the revised rates were applied generally across the board only by virtue of the order of such and such issued by the health department. Then it says, by the order of such 23, such effect was given from June 23. That is the precise date from when effect has been given to the revised rate in respect of the petitioners as well.
yes.
So the argument of the present petitioner is that the document annexed at
That is
page
a recording
170
of fact. That is not a finding.
Correct. But this also reveals that similar rates were applied. That's a question of fact.
These are all
And that
recordings of finding.
and as such fact ought to have been given in respect of the petitioner's revised rate. However, the caption of the document at page 72 clearly indicates the same is in terms of such and such. Successful, however, prima facie evident that the said rates were given effect to.
What
in
the
respect
court
to-
has held is that I have directed for giving effect to the rates. That rates has been given effect to. The court says I find it substantial compliance. The rate, if it is to be from date X or Y, is an issue which I leave open. This is the sum and substance of the order passed by the contempt court, which is apparent from paragraph 16 of the court's order.
So, Lord, in that event, Lord, I would respectfully submit, Lord, your Lordship will clarify that, Lord, whether my entitlement was under based on the 19 or 23, Lord, that will be open to me to challenge. And the order that was passed after initiation of the contempt proceedings, Lord, though, Lord, I can understand, Lord, your Lordship is of the view that, Lord, the paragraph 23 is
No,
clear
just
enough.
see, you please see 16, read it with 23. What
The
remains
revised,
to be clarified?
the revised
If
rates
there was an
also,
occasion, there we would not have asked you.
your Lordship is of the view that, Lord, it's
The
16 says the
direction was give the current rates. If necessary, buy a new contract. They have given the current rates. The court says, all right, this is substantial compliance. Although given effect to by virtue of an order dated so-and-so takes effect as per the said order itself and from June 1, 23. But it records the revised rates, although given effect to. So it has been given effect to, that says that substantial compliance. From when you will get that benefit is an issue. I am not going to enter in a contempt jurisdiction. That order is open to challenge. This is clear and explicit. We don't see anything necessary to be clarified. Otherwise, there is no difficulty in clarifying something.
I appreciate that, Lord. But the only difficulty is that we, of course, Lord, we can be under any impression. I can appreciate that as well. But, Lord, our understanding of the order passed in the contempt
Very well.
jurisdiction is that, that, Lord, the judge has already interpreted the 30th June 2023 order, which is a subsequent order passed after the initiation of the contempt proceeding. And, my Lord, based on that, the judge is now of the view that our entitlement is from June 23 and not from 2019.
Your view is founded on any findings of the court or it is an imaginary threat?
No, Lord. No, but Lord, the clause in the agreement, the previous order, and then the contempt.
Yeah.
So, my Lord, all three read together, my Lord, what was ordered in the writ court in the order by which the writ petition was disposed of, entitled me to the rates from 2019. Now, by virtue of the order passed in the contempt jurisdiction, my right to avail the rates
Where in the Honorable Single Judge's order passed in the writ petition has the Honorable Single Judge said it is to be given from 2019?
Yes.
Please show us.
My Lord, kindly take one's page. Allow me to, my Lord, place before your Lordship page 294 once.
Yes, just read where it says with effect from 2019.
Yes, my Lord, allow me to, my Lord, place this, my Lord. It says, para 290, page 294, it starts, as per clause 26 of the agreement, in case of a fresh tender rate being finalized, which may fall within the period of the contract of the petitioner, the present contract would become null and void. Learned counsel appearing for the petitioner seeks to lend the interpretation of such clause to the effect that the nullity contemplated therein would be only with regard to the rates. Then it is submitted that otherwise the contract between the petitioners and the respondent authorities is continuing. However, despite there having been finalized fresh tender rates subsequently, no effect has been given to the same vis-a-vis the petitioners. It is argued that in terms of clause 26, the petitioner on an equal footing with other bidders who have been given subsequent tenders is entitled to the fresh finalized tender rates. Then, learned counsel further points out that the several representations have been given by the petitioners in that regard, most recently in June 2023, which is annexed as such and such. A perusal of the materials annexed to the writ petition.
Here starts the court's order.
My Lord, my Lord.
Yes.
A perusal of the materials annexed to the writ petition clearly indicates that the respondents being public authorities and the work in question being directly related with public interest. the respondents ought to have acted on a more transparent footing than an ordinary party to contract, inasmuch as clause 26 of the agreement clearly provides that in the event of fresh tender, rates being finalized, the same would be given effect to should be the same would be given effect to in respect of the petitioner. Then, as such, WPA 1315 is disposed of by directing respondent number 2, that is the health secretary, such and such, to consider the representation of 6 June 2023. Now, kindly pausing here for a moment. My 6 June 23 representation was to give me the rates from 2019, which has been discovered based on the tender.
That they have considered, yes.
Yes, yes.
As per the direction.
Correct. And to
In this
dispose of
paragraph, there is a direction to consider.
My
And in the next paragraph, there is a direction to give the current finalized tender rates.
absolutely.
Now we are asking you where it says from 2019. That was the query.
No, well, I'll tell you, Lordship. It is, I can appreciate it. It is not mentioned specifically from 2019, but the interpretation of this paragraph upon such consideration,
So
the
that should
current
have been done in contempt, an interpretation of this paragraph.
well, the current finalized render rate shall be made applicable. Your Lordship
We
will
are
see the use
considering
of
a
it.
totally different issue, whether it was an issue to be interpreted in a contempt jurisdiction or left to be decided in an appropriate proceeding. What is the law?
My Lord, the first law, as I understand it, my Lord,
Yes.
if there is an order by the rate court
Yes.
interpreting a particular clause and having come to a finding based on such clause,
Yes.
and no appeal having been carried therefrom by either party. So, my Lord, that order is binding on the parties to the proceeding.
So who says no? Who has said that it's not binding?
No, my Lord, kindly see the date of the order by which the writ petition was disposed of, 26th of June 2023.
Yes.
Now, as on that day, the current finalized tender rate was of 2023 to 2019. That your Lordship will find, if I may just trouble your Lordship once, there is a finalized rate that then it will become clear. Just one document for your Lordship's consideration. I'll just give your Lordship the page number. The finalized rate of 2019.
We have to examine everything within the confines of a contempt jurisdiction in these proceedings.
Yes, absolutely.
This is not a.
So, Lord, our understanding of the writ court's order was that the writ court has already directed them to give us the finalized rate as on the date of the order passed in the writ jurisdiction, which is 26th of June 2023. And the rate which was applicable on that day through the tender process was the rate of 2019, which was the tender, last tender. This was the discovered. That's why I went to court.
That is an issue not decided. That's an issue not decided in the contempt jurisdiction. That's precisely what we are asking you. Where has this issue been closed that your impression now is somehow all the way thrown out of the scene, or there's no decision on this aspect. They have passed an order which it is available to you to assail. Where is the finding that yes, it is correct, it was not given from 2019, so therefore it is in order. There is no such finding. This is
my limit.
Yes.
My limited submission with your Lordship is that.
Yes.
While disposing of the writ petition, this issue was already closed. That I will get it from 19. That is
we don't
paragraph.
know, but then it may be, it may not be. There is no decision yet whether that order is in compliance with the writ court's order or not. Neither there is any decision yet, nor we are to decide that issue here in these proceedings. So what is the purpose of this argument? That is precisely what we are trying to understand.
So, what we argued before the contempt court is that 2019 rate you have already decided. So this issue could not have been re-agitated at the contempt jurisdiction stage. If
That's
we say
precisely
that,
what we are saying. That is precisely what we are saying. It cannot be. And that is what the honorable judge has said. It cannot be. I just find substantial compliance. Rates were to be given, has been given. You go and thrash it out wherever you want, whether it is to be given from 19, 15 or 23.
this, I was indicating that page number, your lordship will find that page number at 249. This is the disclosed rate of 2019. Just for your
Maybe.
lordship's.
We need not go into that. Sorry.
But these are my respectful submissions. Well,
All
and
right.
that, well,
My lord wants to hear me, my lord?
Yes, yes.
If your lordship wants to, my lord.
Yes, you
I have
are
taken-
waiting since yesterday. Why should we not hear you?
I had taken the point of maintainability of
Yes.
the, my lord, this.
No,
appeal,
the
my lord.
judgments he has cited, those judgments, that is now a settled proposition.
So, my
When
lord,
the
it is not
court
maintainable.
exercises jurisdiction, then any order passed will be subject to appeal. When the court does not proceed for contempt, then it is refusal to exercise jurisdiction.
My lord, that is what I had also said the first day, my lord.
That is
I
the
don't think he has been
settled-
able to overcome the threshold, the first threshold. And my lord, I had also made a submission the first day, giving the benefit of doubt, my lord, that this was an order where something has been decided. It's a appeal under clause 15 of the latest patent. It cannot be because he has himself designated as a clause 19, section 19 appeal. So first, my lord, on the point of my lord, the temporary, my lord, this should not be allowed, my lord, this appeal. Next, my lord, on the point of this, what has happened, my lord, may I just show your lordship only one paragraph, and that's it. I will rest my case.
Of what?
Of the impugned judgment, my lord.
Yes.
Of the impugned judgment. My lord, may I just,
my lord, may I have your lordship's kind leave, my lord?
Yes, yes.
my lord, may I just reiterate the principles of a contempt court, my lord?
Yes.
If the order can be plausibly, my lord, interpreted in two ways, the court will not give effect to a contempt jurisdiction. Generally, that is the principle which is followed.
Yes.
Now, your lordship will kindly come to paragraph 18 only, my lord. This is the
18.
only, yes, my lord, this is the only adjudication made by the learned single judge.
Yes, plausible. That is
Since
the
are
word.
plausible, that is it.
That is
So, my lord, the single judge is only deciding whether contempt can be initiated or not. If there is a plausible reasoning, your lordships are well aware, your lordships are not that harsh. But, my lord, there is not a single decision or an adjudication whether the reasoned order of the respondent number 3 was correct or not. And that has been left to the petitioner assailing it before any other court having jurisdiction, because that becomes a subsequent cause of action. So this is it, man. So, man, on the first point, it is not maintainable. And on the second point, man, again, the learned single judge has only decided the contempt, and the contempt has been to dismiss the contempt, and hence, man, this is not maintainable. But I don't think I need to go into the merits of the case, man. This is the scope of this appeal, man. And my the judgments he has shown also says that section 19 does not allow any appeals, my lord. So, my lord, I am not my lord, adding to those judgments, my
The
lord.
judgment elaborates on the issue, on this law, on the law which is by now very settled.
Very
Order,
settled, my lord.
direction, anything in exercise of jurisdiction.
Yes, my lord.
That is
My lord,
the underlying.
Yes, my lord, the 1988, which is referred to, my lord, 1988 three Supreme Court cases.
Yes.
Para 12 is absolutely clear.
Yes.
Absolutely clear, my lord. That is what I had also submitted before your lordship, my lord. That the right of appeal is a creature of statute, and you cannot get it if there is a droppage of the contempt proceeding.
Yes.
The division bench I cited, it considers 88 and previous 74, and it says that 74 is what we follow.
Correct.
But 88 is also a judgment of the Honorable Supreme Court.
But our division bench has interpreted both.
My lord, 75 Supreme Court, if your lordship sees, is something which it says, my lord, kindly see 75 Supreme Court.
No, the
May I take
division,
your
your-
lordship's kind leave, my lord?
Yes,
Lord,
yes,
I have a
you may.
duty
Yes.
of life. My
In
duty
fact,
as well.
the division bench has considered 74 and 76 both.
And my lord will kindly see 75, my lord, 1975 three Supreme Court cases.
Yes.
Paragraph 8, my lord, this question was not at all decided. My lord, kindly see
In
it is,
paragraph 16, where it has considered 76 and 74, the
my lord,
division
is
bench, the division bench,
Yes, yes, my lord.
if you will see, it says, on the other hand, it formulates the proposition that only those orders or decisions in which some point is decided or finding is given
My
in
lord, I have,
exercise of jurisdiction.
absolutely, my lord, I have also considered to that, my lord.
So the
And
division
75
bench
Supreme Court
also.
does not even decide on it.
Yes.
75 Supreme Court says that we are not going into the question of section 19 appeal and who can make the appeal. And paragraph 8. my lord.
75 is the earlier one or the subsequent one?
My lord, this is the earlier one, which
You are
1974.
giving the SCC citation. Here we have the AIR citation.
Oh, I'm so sorry, my lord. My lord, this is Bharadakanta Mishra versus
Yes,
Mr.
Bharadakanta,
Justice.
there are two judgments. One is of 1976 Supreme Court 1206 and one is
My
1974.
lord, I'm talking about the judgment which was decided on 21st June 1974 on contempts of court act section 19(1).
Can you give us the citation, SCC citation?
This is my lord, 1975.
Yes.
3 Supreme Court cases.
Yes.
535.
535. They have referred this. Yes, we need the citation so that we know what he's saying. Which judgment?
They have given a copy to you.
75 3 Supreme Court.
No, yeah, this one.
Oh,
I'm
yes.
reading his judgment.
We have
I'm
it.
only,
We have it.
yes,
Yes.
but I'm only reading the judgment which he has shown.
Hmm.
My lord, for the completeness, then, my lord, may I just place one judgment? My junior is there, my lord.
This 73 you were referring to which paragraph?
My lord, 75, my lord.
75 3 you are referring to which paragraph?
My lord, kindly takes paragraph 8, my lord. The last paragraph.
Yes.
But it kindly comes to the second sentence. We may point out that in the present case, it is unnecessary to consider whether an appeal under section 19(1) is confined under a case where the High Court, after initiating a proceeding of contempt, finds him guilty and punishes him, or it extends also to a case where the initiating a consent for contempt and exonerates him. So this question was not decided.
Very well.
And my lord, may I just give one judgment, my lord? 1996 4 Supreme Court cases, 411. My lord, my junior is there, my lord, he'll hand it over, my lord.
1996.
This is State of Maharashtra versus Mahbub S. Ali Bhai. Kindly takes, my lord, paragraph 3 and 4, where, my lord, very lucidly, my lord, it has been discussed.
Yes.
There's some problem with the
Disconnected.
link. দেখুন না,
My lords, there is some issue with the learned GP's link. My lords, may just allow me 10 seconds, my lord. I'll just get him connected back. My lord,
Yes.
just 10 seconds.
Yes.
Lordship, appearing for the petitioner, your Lordship, the judgments which are being relied upon. Lordship, am I audible to your Lordship?
You are, please wait.
Lordship.
I'm sorry, my lord, I got disconnected, my lord.
Yes, yes. So
My
we
lord,
have
kindly
seen
comes
3
to
and 4. Yes.
My lord, so that is basically the, my lord, it is upholding of the judgment of the earlier, my lord, relying on it. This is the only finding, my lord, it's between the court and the, my lord, alleged contemptor. And therefore, my lord, Bharadakanta Mishra also has been referred to here.
Plus, all the issues have been left open to be agitated in a
Yes,
process.
that is the most important. Malad, if the order was to be a reasoned order, if the reasoning is right or wrong, Malad, that goes before another forum who will decide whether reasoning is in terms of that order or not. Now, the single judge has only said that yes, this is a plausible view. Therefore, I'm not. Malad, can hear me?
Yes, very well.
Yes, yes, Malad. So, Malad, that is the plausible view. Therefore, I do not exercise jurisdiction which I have specifically against the alleged contender. I am not taking that step forward.
Yes.
But that does not say that, no, the order pass is correct. If that had been said, Malad, maybe we could have considered that it is maintainable. But it has not said so, Malad. Malad, those are my submissions, Malad.
Very well.
I am also led by the learned Advocate General, Malad, but Malad, those are my submissions. I don't think I can add to it anymore, Malad.
Yes. Yes.
Lordship, the judgments which are being relied upon, Your Lordship, may we be extended an opportunity to reply to the same in the event Your Lordship allows us.
Which judgment? There's only one judgment he is citing.
Lordship.
He's relying on your judgment. Yes.
Relying on her judgment, Malad.
Oh,
Yes.
Lordship. Could not follow Your Lordship.
Very well. Heard the parties.
Lordship.
List for orders on first.
Lordship is pleased to direct the matter to appear for orders on 1st of May.
Yes, we have heard the
Lordship.
hearing is complete. Yes.
Lordship.
Grateful, Lordship.
Grateful, my lord.
Next. Call the next case.
Number 5. I am for the respondent number 125 in item number 5, Lordship.
By the time we reached home, it was relevant. Who went in a lot of trouble also.
I am for respondent number 125, Lordship. This is the writ petitioners.
I have, Lordship will kindly consider the court in one hand is saying that the court has not gone into the merit of the matter. On the other hand, the court is of the view that if you give him the benefit, you have to pay the interest and other directions given therein, which is absolutely irrelevant in the context of the present case. Whether entitlement of A category scale is a matter to be considered by the court, and one court is already insisting of the matter. As per the that will appear at page 82. As per the order of appear at page 84. As per order of court, my lord, A category scale is liable to be given to someone who has completed 1 year or 2 year diploma course in BH prior to 2005 December.
No, but he is
That is
appealing
why
in
the
this case.
Where the 1 year diploma course was directed to be
Yes,
treated as
started. We don't even know what
nullity.
he is saying. We can't follow anything.
2005 the case was started in Pichiboxi, so the court has given prior to Pichiboxi matter, whoever has completed the higher the B.Ed course, they should be getting the benefit of the A category scale. That
Cannot
is the matter
understand
to be
anything that is.
scrutinized by the respective counsel.
From the very first day this is taking place, Lordship. From the very first day of this hearing, Lordship. Of this matter, Lordship.
First day of the hearing, the writ petition was disposed of.
No, let's
Without manner opportunity of hearing, directed to be considered by of court. But the second part of the order, directing that we have to pay the interest, we have to pay the other benefits, that is appearing at page 79.
Just wait 2 minutes. Wait for 2 minutes. Wait for 2 minutes.
Yes.
Page 79 is the, my lord, the lordship.
Yes, what do you have to say? What is, you are aggrieved by what?
I am drawing the lordship attention to page 80 of the said improved order. That is running page 80.
Which paragraph? Page
In the
18.
event, my lord, second paragraph. In the event the rescind order goes in favor of the petitioner,
Page 18.
appropriate state authority shall give an immediate effect thereto. Very good, my lord. Along with the arrear payment, all right, my lord, if any payable in the petitioner, together with interest at the rate of 4% per annum. How the question of interest coming, my lord, that is a question of fact as to in whose fault, my lord, the payment could not be given.
All
Other
right,
division
we
bench
have
orders, my lord, that
understood,
is-
we have understood what you are, we have understood your grievance, don't worry. Yes,
My lord, may I?
yes.
Firstly,
Other
my
division
lord,
bench also might have said that we considered, but no interest has been direct.
firstly, my lord, they have complied the order of passed by the honorable single judge lordship.
No, no,
Hearing
first
has-
tell us, according to you, you are entitled to this A grade since when?
As per the terms of the division bench's order, lordship.
Since? What is the date of the division bench order?
Division bench stated that lordship, from the date of the examination, I am entitled to get A grade pay scale lordship.
So according
No,
to
no,
you,
no.
Lordship.
you will get it with effect from which date?
61 second.
Let me check lordship.
Page,
Just
page 14, well, 14, page 61. Page 61, এখানে আছে এই যে। That was the 2020 order.
The division bench order is on record.
lordship. Two division benches order are there. One is at page number 42 and another is from page number 45. First is from page number 42, lordship.
There are two pages. The writ petition, it is 42.
Please mute, please mute him.
61.
Mute him. Yes.
From 2011, lordship, I am entitled to get the A category pay scale benefit, lordship.
And what is the date of the division bench order?
That was 23rd January.
Please,
2020.
Mister, we ask you, you please respond. Don't keep saying something or the other unnecessarily. Yes.
It's not legible properly. It's their copy, lordship. On 2020, it's written
So
in their
2020, the division bench said to give it from the date of examination.
lordship. From
From the examination or from the date of result of the examination?
Examination was conducted in the year 2005 and 6, lordship, and result came out from 2011, lordship, and from that date the division bench ordered.
So from the date of result,
lordship.
you were a party to the division bench judgment.
No, lordship. By showing that order, and I was
So
similarly
2011, they were held entitled with effect from 2011 by the division bench in 2020.
lordship.
You approached the High Court for the same relief.
Same
By the writ petition, which is now the order of which is subject to the present
lordship.
appeal.
Lordship. As I was similarly situated, lordship.
Similarly situated.
Now, lordship, the Honorable Single Judge directed Siliguri Primary School Council to consider my representation in terms of the two division benches order passed by the coordinate division benches of this court, lordship, and also held that if there is a delay, I am entitled to get 4% interest, 4% per annum, an interest of rate of 4% per annum, lordship. But Honorable Single Judge has not passed any mandatory order. He stated that let my representation be reconsidered, Lordship. Now, what they did, Lordship, they complied the order and hold the hearing, Lordship. Hearing has been concluded, Lordship. On 19th and 20th March 2025, 2 consecutive days hearing took place, Lordship. And now they have filed this appeal, Lordship. And by showing this appeal, they are stating that they will not pass any order in terms of the division bench's order. And here they are dragging the appeal, Lordship. And Lordship, kindly come to page number 79, running page number 79 of their application, Lordship. The third paragraph, Lordship. It says that the entire exercise shall be carried out and completed by the respondent number 4 positively within a period of 6 weeks from the date of the communication of this order. Now, this notice says that I have served the copy of the order. That's why they issued a notice upon me on 7th March 2025. Yes. They issued a notice to me on 7th March 2025. Last day, I also handed over a copy of the notice, and this is another copy. And on 19th and 20th, 2 days consecutive hearing took place. Now they are stating that
That's not the issue. You are arguing something which is not an issue. What they are saying is why they should be saddled with interest.
Lordship.
That is the only issue they have argued.
Lordship.
Whether they are hearing, whether they are not hearing, whether they will wait for.
But they have followed the order partly. Now they are not.
You want to say anything on that, or you don't want to say that? This is the last time we are asking you.
On the point of.
That is the only thing they have argued. You are, apart from that, you are saying everything.
Lordship.
Therefore, we are asking you want to say something on that,
On
or
the
you
point of
don't?
interest, no.
Yes.
I don't say anything, Lordship.
Then how can you get interest? You are claiming parity with someone. 2 division benches have not given interest. And when you are claiming for parity, the single judge gives an interest. How it can be? How can it be? They are only saying that how the interest has been awarded. It may be from 2011, the division bench has held that you give it from that 2011, it has not given interest. Both the division bench, see?
Lordship, both the division
That is
bench
the only
that-
thing. We'll clarify that. They will complete the process immediately.
Lordship.
How much time will you take?
Lord, 8 weeks, my lord.
Already.
If already hearing has been done, why should you take it?
Within a week, Lordship.
Suggest a reasonable time. Do it within 4 weeks. Within a month.
4 weeks, my lord. Let there be 6 weeks, my lord.
No, 2 weeks.
No, one.
Obliged.
Yes.
But as your lordship may deem fit and proper.
What is this bargaining?
No,
4
no.
weeks, 6
I
weeks?
beg of your pardon.
Third learned counsel for the parties. The petitioner approaching
For item 6, my lord.
Yes.
This is my appeal, my lord.
Yes.
But this can 3 is pending. But 2 can, that has already been, that is can 1, that is a condonation of delay in filing the appeal that was allowed on 3rd October 2023. And so far as can 3 of 2022, that is a substitution application upon death of respondent 1, that has already been allowed. Can you also kindly see that order? If you also got it, my lord?
Yes, we have seen it. So which can is pending? Can 2?
Can no. Yes, can 2, that's a stay application. Stay application.
Yes.
But I have to sub copy.
Respondent.
Yes.
I'm on behalf of the respondent.
Yes.
Respondent. But I have to sub the copy of the application for stay. Have I?
You represent
No,
all the respondents.
No. I haven't.
That-
I'm 2, 4, and 5.
Has the notice been served on all the respondents?
No. There's no direction. I have not yet served. The suit for partition is a preliminary degree has been passed. I filed this appeal, my lord, and then I have to serve. This appealing for the
serve
first
them.
time.
Please
I
serve
have
them.
to serve. But in the meantime, what I am submitting before lordship, your lordship knows, is a partition suit. Preliminary degree has been passed. I preferred an appeal that commissioner, the all work will be done, my lord. Only, my lord, commissioner work is to be done, but only final degree will not be drawn up. That is the usual order. Possibly your lordship knows.
Yes, we know, but then can it not be passed after the notice? What is the great urgency?
Yes. Right. I have to serve. But on the interim order, that is why. Yeah.
Come
Submission.
back. It will hardly in the next circuit. It will be taken up.
Yes.
My lord, all are contesting the suit, so all the parties should be.
Yes, they will be.
I know it, brother.
That
I
will
know
say-
it. I have to serve upon all,
Yes.
including substituted.
Let
Including
notice be served on the respondents by speed post.
Yes.
Affidavit of. Yes, Mr. Bhattacharya, it can be done within a week.
Yes. Within a week.
List in the next available circuit. First week of the next available circuit.
First week. I'm grateful, brother.
Lordship, in item number 7, I appear on behalf of the appellant, Lordship. Yes, Lordship, I honor the appellant, Lordship. There was a direction to paper publication, Lordship. Paper publication already done, Lordship. Kindly fix the matter next week, Lordship. I submit the paper all and affidavit of service, Lordship. Paper publication, Lordship. Service of, yes, Lordship. Yes, Lordship, next date, Lordship.
So one indulgence, my lord. My lord, no, my lord, when criminal matters are from item number 35. 35, my lord. So I hope today, my lord will come to reach. A lot of matters are there tomorrow. I'll get from them.
Lordship, item number 8, I am appearing on behalf of the respondent. Although I find that there is a defect, but I have received a copy of the appeal. It's the appeal against a preliminary decree. The appeal against preliminary decree.
Number 9. 9, my lord, is a second appeal for admission. But my lord, there is a delay condonation application, my lord, subject to correction. It has to first appear before the honorable single judge. Then probably your lordship would consider it for admission. The can 2 is my lord, the application for limited.
Application for condonation within bracket can 2 of 2024
Yes, ma'am.
is pending consideration, full stop. That comes before the appellant. Item 8. You were just here. No, the order has been passed. The respondent was here. You were not here. What can be done? We have kept it after 1 week.
Item number 10.
Can bring for next service? Petitioner is suffering from fever, Lordship. He's an old aged person.
You are here. Petitioner is not required to be here.
To file the can application for condonation of delay.
As split, like next set.
Number 11. Item number 12.
It's a Matrimonial appeal, my lord. It appears today first. I take it Monday, I guess in our site. But this is a marriage took place 20th June 2002. She left on 2003. What's paperwork is that the paperwork to the I just I give the notice of the sale.
Can is pending.
No, I did this one. Paper was I prepared money. Served upon them also. Next 2 years, I just give the notice. I take the instruction also. There's a 498 case. So kindly next week, Monday or Tuesday, I give the notice then.
As split, list after 1 week.
I give the notice them. Yeah, so there. I like that is straight. Cost that is straight. I know you're not speaking. Okay, Tuesday, Monday, I give. Monday.
Yes, we will give you the date. It's after.
Monday, Tuesday, Monday.
1 week, we have said 1 week.
Item number 13. Item number 30.
That what's DCR has been received. TCR has been received. No paper book has been prepared. Nobody's. There is none to represent either of the parties. List in the next available.
Now 14.
Your Lordship, I'm praying for next circuit. Section 5 has not been filed and the delay needs to be ascertained. I went to the department also. They could not, so I have to take from the records and I have to ascertain it. Yes. I have to. Earlier order for removing the defect. No. No. File. Folder. For this criminal appeal. This is bail. Your Lordship, suspension of. Delay has been reported. I need to ascertain it. I went to the department, the record was not there. It is here. So how do you know you have to file a section 5 application? I was instructed that there is a delay. It should be a report. Out of time. There is a note.
There are 15 and 16.
But pursuant to your lordship's observation yesterday, Millard, I had communicated with my husband.
Yes.
He is agreeable to come on any day.
Yes, my client is agreeable on 30th.
30th. No difficulty. Millard.
Kindly fix 30th.
We are the learned counsel stroke S.
If I look at that, so practical. আমার কাছে যখন
So you will have to agree to some remuneration for her also.
We'll agree, my lord, no difficult.
What do you propose?
But I leave that to your lordship. না, আমি তো
করো দেখি বলি
You are agreeable to be present when they meet. We are informed that you have agreed to be present when they meet. Since we consider it appropriate that the parties meet, but not in
Award was passed, but 34 preferred, rejected. Now 34 before Lord, 37 before Lordship.
37.
Next, yes, read this matter. Read this matter, Lordship, matter is related to the 37 petition. Our application discussed on the ground of limitation. Now it's kind of fix the next week anything.
That council for the Appellant.
Number 18, this is my, I'm for the plaintiff appellant, my lord. I filed this is the first appeal. There's a point is that, my lord, I filed a suit on the point of title deeds. My suit was dismissed on the point of limitation under section under Article 64 into Article 65. My lord, now they have filed an application additional evidence file. I have to give a reply to that.
Well, there's a direction to file their opposition to can 3, which is not filed yet.
Oh, I can't file it because
Already there is a direction to file.
Yes, I can't file.
You have not filed yet
No, I'll file it tomorrow, plan will come.
for filing opposition to can 3.
Can 3.
Can 3. That comes.
Lordship, on last official, the matter was pending since 2023. That's why previously I have been directed to issue the notice again, and I complied the same. Previously also this respondent didn't turn up.
Somebody has entered appearance on her behalf.
Lordship?
Has anybody entered appearance on her behalf?
No.
No, because we find an order to serve a copy on the advocate. So on which advocate if they are not represented?
The conducting lawyer of the law.
Now how that person will have any power? That is over.
Yes, but this court directed me, that's why I complied the same. Actually, maintenance case is pending before the court of law.
Oh, maintenance is
That
pending.
particular conducting lawyer is also conducting this case, that case. That's why the considering that.
So it has been served.
Yes.
Where is the service?
Lordship.
But you have not served on the advocate. Notice has been taken out on the. Yes, where is the service on the respondent, on the advocate?
Lordship, maybe it is the mistake of my junior. I may be given one.
So without examining, without looking into it, you come to the court
Lordship, I am very sorry.
for us to point out that there is a mistake committed by your junior.
Lordship, I am very sorry.
Pathetic situation.
Here it is respondent and her learned advocate. Yes, I find it.
So it is on the respondent only.
Only respondent.
The affidavit of service has been filed showing
And for the petition.
Yes.
yes, what do you have to say?
Lordship, in this matter, the LCR has been called for in the month of September.
TCR, not LCR.
Yes, trial court records has been called in the year 2023, and since it's due since very long, my humble prayer is a fresh direction be passed so that the TCR be called for.
Your Lordship, I'm appearing on behalf of the Indian
On what date the direction has been issued for TCR?
Lordship, 18th of September 2023.
No, there is a last order of 2nd April to serve copies on the respondents.
Yes, Your Lordship, we have received it. Your Lordship, we would like to file opposition, definitely in opposition, Your Lordship, because they are seeking for mean profit, Your Lordship, and in this regard, we would like to file kindly give a direction upon the respondent bank to file the opposition, Your Lordship, because the appeal has certain lacunas, factually incorrect documents, Your Lordship, as per my instructions, so we would like to file opposition.
You are
to that.
for the bank.
Yes, Your Lordship.
What is the order under appeal?
The order under appeal is dated, Your Lordship.
No, what is it? What is the issue?
Your Lordship, the bank used to have a branch at the property of the appellant, Your Lordship, and subsequently, the landlord had passed away, but they had not substituted, so there was a certain difficulties to make the payments, Your Lordship. So in that regard, the problem arose, and subsequently they had evacuated the property. The bank has already evacuated the property, but they are seeking for mean profit, Your Lordship. That has been they have received the petition 2 days back, Your Lordship. I'm not holding the brief right now, Your Lordship. That is the difficulty. But as per my instruction, Your Lordship, we need to file opposition because the petition has certain lacunas and factually incorrect documents, Your Lordship. So we would like to bring that into the notice of record of the court, Your Lordship.
Because the first to be transmitted. Then after that. No, it's inside that. 21, 325.
It is against the judgment dated 19th of September.
Earlier, the TCR was received
But due to some defects, the TCR
was
was
re-
again sent.
returned back to the
Yes,
court.
ship.
The Learned Council is presenting the appellant submit
Lordship, I am on behalf of the appellant. Lordship, in this matter, talks going on between the parties. I'm for the husband. There is just talk of the settlement between the husband and wife. So kindly adjourn the matter for next circuit.
Respondent has appeared.
Earlier, he appeared Lordship on 12 November 2024. Kindly see the order, Lordship.
According to the learned counsel for the appellant, the parties are
Number 22.
There was a direction to fight paperbook. My paperbook is ready, ma'am.
served.
Why not the opposite party, if they are present, why not I'll serve today itself.
Arises out of
Why not rise? FAT 10 of 2023, madam.
what was the suit for?
A rejection of plaint, madam. The plaint was rejected.
What was the suit for?
The suit is for my lord, recovery, and it was a specific performance of contract.
What is the can do?
And to add file an injunction application.
Hmm? Can one has been allowed?
Limitation, madam. If the direction paperbook, madam, I have prepared my paper.
The counsel for the appellant is submitting the paper books in compliance of the earlier order dated 20.
I appear for the respondent.
23, my lord, I beg to appear for the appellant, my lord.
I
There
appear for the
appears to be,
respondent.
my lord, on board, my lord, an application being CAN 6 of 2023. This is a first appeal challenging, my lord, a rejection of plaint, my lord, made by the learned court below in a suit for cancellation of a conveyance and perpetual injunction. Now, there's an application on board, my lord. That application, my lord, has been filed apparently by certain third parties seeking their addition to the instant appeal. They were not parties to the suit. They are seeking addition to the appeal. I am humbly, my lord, submitting, if your lordship permits us to use affidavits in that application and let that matter come up thereafter.
Very good.
This CAN number?
CAN 6, Milad. What
My
is
lord,
happening
6
in this?
of 2023.
CAN 6.
My
CAN
lord.
6.
CAN 6.
CAN 6 has been filed seeking an intervention in the appeal. Stop learned counsel for the appellant submits that the appellant will use an affidavit in respect of CAN 6. Stop. We allow filing of such affidavits. Stop. Reply, if any, be also filed by the applicants. Stop. Matter to come up in the next circuit.
Obliged.
Obliged.
Number 24. The counsel for the appellant seeks next circuit, your lordship.
Why?
Actually, the counsel is physically ill, so there is a slender chance of him being able to come here.
We are informed that the learned advocate representing the
Twenty-five, I'm praying for 1 day accommodation.
My lord, I am appearing on behalf of the respondent in this matter, my lord.
Actually, Mr. Supriya Chattopadhyay is appearing for the petitioner. This is not well today, Lordship. Kindly not today.
Very well, not today.
Great, Lordship.
Lordship.
Number 26. In terms of the last order, Millard, the application for stay was allowed. Injunction was granted, Millard. There's a direction for filing paper books. That the lower court receipts have just been received, Millard. Paper books will take, Millard, 2 more weeks.
All right. The learned counsel for the appellant submits that the trial court record
Number 27.
records.
I am appearing for the applicant.
Yes.
So, this appeal has been preferred against an order of injunction, order of status quo passed by the landed civil the senior division at Alipurdua, and the impugned order in paper book has been prepared. Lordship.
Respondent.
Impugned order is in page number 40 of part 1.
This, you have served on the respondent also?
Yes. Only one respondent I have served, and they have also appeared earlier. Impugned order is in page number 40, part 1 of the paper book. I have challenged the impugned order on 2 basic points, that is doctrine of clean hands and non-suppression of material fact, that they have
17/8/24. What is the order's date?
17/8/2024.
Yes.
I have challenged mainly on two points. Suppression of material facts.
Yes, the agreement is admitted.
The agreement is not admitted. It appears from the order that it is admitted, but agreement is not admitted. I have vehemently challenged.
Where is your WS? Where is your reply to the
Lordship? So kindly consider page number 94 of the part 1. 92 onwards is my additional written statement, which has been accepted by the.
It is not here.
Page number 92 onwards. And
92.
92. Part 2, Lordship, there are the pleadings. So, in the part 3. It is in. No, Lordship. Page number 20, 20 to 28, part 1. What are different can be? 20 to 28. In page number 21, paragraph number 7, page number 20, last paragraph number 7, continuation in page number 21. I have said under what circumstances the agreement has been executed and what are the facts that was actually suppressed by the plaintiff while approaching the landed.
Where have you said?
In page number 21. My specific case is.
Part 1, page 21. 4 at page 71.
My specific case is that such agreement was never executed by me. I have appointed the plaintiff as my attorney, power of attorney, to negotiate the price. Since he was known to me for long and I lost my husband, so I was unable to take care of my property situated in another district, that is in dependent resides in Siliguri and the property is in Alipurduar. So I appointed the plaintiff as my power of attorney to look into the property and to negotiate the price with the intending purchaser. But my attorney, what he did, while such power of attorney was being registered power of attorney. And that power of attorney I have produced. They have suppressed all such facts. I have produced before the learned court. I have specifically pleaded in my written statement and written objection. But such fact was also never considered by the learned. Registered power of attorney. And the agreement based on which they have claimed, my lord, if such agreement is in page number. Page number 4 of part 2, Lordship. Page number 3 and 4. Lordship, it is a 2-page agreement, and several pages are left vacant, left blank, subsequently filled up. It can be found that in page number 3, in the recital, the pages have been left. That was in
Where we are not going to do that. So the child court has granted only on a read.
Is it to
But then he said that study, why they could there, didn't go to that is 20.
The objection is at page?
written objection?
Objection to the application.
Page number 29 onwards. In page number 34, I have specifically stated in para number 13 that with respect to the purported agreement dated 24th March 2021, the defendant office submits that the plaintiff petitioner obtained her signature on this agreement fraudulently, dishonestly, and by way of misrepresentation. The defendant office further submits that the agreement.
Then what is wrong with the trial court's order? Whether it is a forgery, whether it is by deceit, that is what remains.
Matter of trial.
Huh?
I consider on that part.
Then that is what the trial court has considered. What is wrong with the order?
This agreement is on executed as per the version of the plaintiff. This agreement was executed on 24th March 2021. Just before, kindly allow me. Just 7 days after this agreement, one registered general power of attorney was executed in favor of the.
That's not the point. We are not hearing out the suit.
No.
What is wrong with the order that we are asking you? There is an admission of existence of an agreement.
Lordship.
That has been by deceit or by fraud. That will be
Lordship,
seen as.
kindly see the consideration amount in that agreement.
We are not concerned.
No,
This is not the time to look into that.
No, Lordship.
This is only a strong prima facie case and to preserve the list.
That is why.
That is all.
Especially in a suit for a specific performance of contract, a contract must be consignable. The quantum of.
Correct. Before a decree, it must be seen. You are right. We are not passing a decree at the moment.
Lordship. 7 days later.
At this moment, only the pleading has to be seen, nothing more.
Then my submission.
Please show us the law that we have to look into all of this. We don't have to. This is the time looking into the pleadings. You had the option. You had the option to file a pleading. You have filed an objection where you admit to existence of the agreement, which has been recorded by the trial court. So what is wrong with
I have explained the circumstances that has not been considered.
That will need not be considered at this stage. That need not be considered at this stage. The law is very clear.
One registered general power of attorney is in existence. That is registered general power of attorney is in existence. That fact has been suppressed by the plaintiff.
So maybe you will succeed. Maybe you will succeed in the suit. Who knows?
No.
We are not hearing of the.
That was suppressed. They did not approach the court with clean hands then.
All right. You don't find any force in what you are saying. We don't find any force in this argument.
Lordship, then I want to place reliance on some Supreme Court order. Lordship.
Yes, shows.
The mere prima facie case is not sufficient to grant injunction.
Who's saying that mere prima facie case is sufficient? There are three ingredients. There's a golden rule of three ingredients.
That is-
All those three ingredients you need not impress upon this court.
Lordship,
We are conscious.
Lordship, then kindly consider my submission.
Yes.
That in the agreement dated
Yes.
24th March 2021, the consideration price is written as 2 lakh rupees.
That may be wrong. Maybe you are saying what is it? Maybe a deceitful act. We don't know. That is yet to be considered. These issues are to be argued.
Lordship, the
If
value
the
of
matter is
property-
decided
Lordship,
against
value of the property as mentioned in the power of attorney that was calculated by the registration office is 1.11 crore. Any reasonable man with reasonable prudence would execute a agreement to sell in favor of any person of a property having value of more than 1 crore with rupees 2 lakh only. I asked this question to myself. So there was, and that fact was suppressed by the plaintiff before the court. And the court also did not look into such fact. Then where will this
the court will embark on a trial for injunction.
I am not.
Under order 39.
No, Lordship, I am not.
Are you
I am
submitting,
not,
sir?
No, Lordship, I am not. I am just emphasizing to consider this point. I have.
That is why we are asking you. This is
I
the
have
stage to
placed such
consider.
fact
This is the stage to consider these things. This is not the stage to consider.
Then, Lordship, I ask this question to myself.
Yes.
What is the principle of doctrine of clean hands and non-suppression of material facts?
Yes.
If any fact is suppressed and I place it before the court and the court also did not consider such fact, then what remains with such doctrine? Lordship, I want to rely on a judgment of 2025 STC Online Supreme Court 556.
Yes, give the judgment. What judgment you say? Where is your friend? Who is appearing for the respondent?
Lordship, I have several. Mr. Sudipta Majumdar is appearing, learned senior counsel Sudipta Majumdar is appearing for the respondent. I have served the copy.
Ask him to be here, not today. Tomorrow.
Yes.
we will- Please intimate him.
Yes.
PTA
28 and for the respondent, Lordship.
Rising out of?
But arising, so the father gifted my lord 3/4 share to the son and 1/4 share to his wife by the way of gift deed. Thereafter, my lord, the plaintiff, who is the son, who has given 3/4 share, my lord, he filed an application before the district delegate Mathabanga, being a misprobate case, from which the title suit has been arisen. And my lord, the order, the suit has been dictated in favor of the plaintiff, the son, which has been challenged by the one of the daughters, who is the defendant number 3 in the title suit.
You are representing the son.
I am representing the son. The mother was defendant, another daughter was
All those who are claiming out of 3/4, they are.
My lord, one of the daughters, my lord, she has, my lord, contested the suit, and here, my lord, he is the appellant.
Where is
She
he?
lost, and therefore she is the appellant before your lordship.
None appears for the appellant. In presence of land counsel for the respondent. Matter is adjourned to the next circuit.
Wow.
Hmm.
29. Item number 29. Next is for. Item number 30. Item number 30.
I can't for the respondent, your lordship. Your lordship kindly fix this matter next week, subject to your lordship convenience. Any days of. Okay. Huh?
31. 31. Item number 31.
Lordship, kindly make it not prudent. Next week, Lordship. Appellant, my lord, Mr. Minalkanti Vishwas, my lord, he is appearing, my lord, virtually, but I am not finding him, Lordship. Owner, Miss Lordship, he is appearing, Lordship.
My lords, regarding item number 31. Regarding 31, I am appearing, my lord, in this matter. For the petitioner.
Oh, it was taken up by us earlier also. No, 22-4.
I take copy of the
Oh, yes.
Your lordship wanted that memo.
Show us.
I got only one copy and just obtained one.
No, give us 2 copies. Give us 2 copies.
What password?
You give the copy to them also so that.
Yes,
they-
I will get the Xerox.
Yes. No order is being passed, not today.
My lord, then on Monday, my lord.
All right, on Monday.
Monday, deeply obliged.
Take it.
But I'm for the respondent now. But I'm praying for next circuit.
When they are here, you make a prayer. What do we do? Two matters. Next circuit.
Get.
Well, 33 and 34, my lord, I am appearing on behalf of the appellant, my lord. This is an order against, my lord, the West Bengal State Administrative Tribunal.
Yes. Yes. Let us see.
Yes, please. One of the
Arakchul advocate, please. Lordship, we are in item number 33, Lordship. 34, there is safe.
Respondent.
Yes, Lordship.
Well, 33, my lord, the 33 and 34, both the petitioners, my lord, the employee of the police service, my lord, they are the constable. My lord, 306 case was initiated against them. And my lord, also, my lord, the prosecution with the police case started and my lord, departmental proceeding was initiated. My lord, initially at the, in that, my lord, that criminal case, the petitioner was convicted. Malad, after conviction, Malad, the kindly see Malad page 21, the order of the departmental in disciplinary authorities order. Page 21, Malad, kindly see.
Where is the order of the tribunal?
Tribunal last.
Huh?
Pending, still pending.
Which order of the tribunal is impugned?
Impugned order, Malad, page
What
last
is the
order, Malad. This,
date is 14/9/23.
Yes, yes.
yes, yes.
Last is. Page Page number for a little.
Yes, 35 copies. Yes, sir.
আমার তো মধ্যে মনে নেই এটা এটা ওটা তারপর তার কি আছে supplementary expense বলছিল পার্কিং
So what is the order that you have challenged? You don't
Malad, in
understand.
the tribunal, Malad, they transfer the matter to the division bench. Last 3 years, Malad, there is no division bench in the tribunal. As such, Malad, this matter was accepted by this bench. For Malad hearing this matter, Malad, adjudicating this matter for Malad, there is on merit. Malad, kindly see the admission order, Malad.
Where is the direction for placing before division bench? Please read.
Kindly see, Malad, this is a division bench, Malad, the division bench of this tribunal.
There is a
Division
direction.
bench.
There is a direction to place before the division bench.
Yes, Malad, kindly see, Malad, that last order, Malad, 8th February 2024. Malad, the last page, Malad.
8th February. No, the order impugned is 4th
4th
September
February
20.
as well as Malad, the 8th February, Malad, this 8th February, that date, Malad, matter was referred to the division bench.
There is only one order of the tribunal, 14 September 23.
20th September as well as Malad, the 8th February. Kindly see the order of the 8th February, Malad, last page. The single bench relating to disciplinary place the bench comprising 2 members.
Eight to 24, yes.
Yes,
What
but
is there?
there is no division bench last 3 years. As such, Malad, this honorable, Malad, this division bench, Malad, admitted our applications and Malad, and the affidavit already exchanged. Malad, already directed to file affidavit in opposition. Malad, already affidavit opposition reply. All Malad's pleading already completed. Malad,
No, reply has not been filed, so. Reply has not been filed. But the matter is pending. That's what Quran is.
yes, there is the pending matter is a fact, but last 3 years there is no bench.
আমরা পাইনি তো।
আমরা দুই অনির্বাণ তো আসেনি ওর তো ম্যাটার
Yes, what is it?
Another matter.
So Lordship, in our case, we did not receive any reply and there is a separate counsel in item number 34. So Lordship, we just received the reply.
From? They are filing a reply.
Now, my point,
By which order this court has admitted this appeal?
but as for order passed by the Honorable Justice Malad Joymallo Bagchi and the Honorable Justice.
Please read what it says.
Malad on order dated Malad 16th May 2024.
Yes, it is an admission order.
The Lord Landed Council submit case was referred to the bench comprising 2 member judicial and administrative member by single member tribunal, does not have requisite quorum and constitute the bench. Hence, he has approached this court for relief. Land State is directed to submit a report regarding availability of the bench comprising 2 members as on the next date of hearing.
So this is an admission order.
No, but that till today there is no only single
Why do
member.
you make a wrong submission?
Admission means there is no provision regarding this appeal.
Then
We
why do you make such a submission?
Well, this
You
submission.
are trying to make out as if that hurdle you have already crossed. We asked you why we should take up the matter. You said it has already been admitted. Where is the, we are going through the entire order. There is no order of admission.
And also
Now you say admission is not required.
But thereafter the affidavit direction was there.
No question of the. See, you must have seen L. Chandra Kumar judgment.
But that division bench is not there.
When it will be there, everybody is waiting. You also wait.
No, if there is no bench, why are you waiting? 2017 matter.
Very well, you can.
Why waiting? 2017. If there is a bench last 3 years, then this petitioner cannot be a remediless.
There is not
remedy. There is no remedy. A tribunal last 3 years, there is no division bench.
And what was directed by the tribunal on 14/9/23?
14/9, there's the next date, 8th February, directed the matter may be placed before the division bench. Before the 2 judges, member. This is a disciplinary proceeding matter. As such, that single bench, he is unable to hear out the matter, 8th February 2024. I'm a retired employee,
We appreciate what we are saying. We appreciate what you are saying, but we cannot take up all the matters pending before the state administrative tribunal. It may be in an appropriate case where something can't wait for a day in a very exceptional circumstance.
But in this
the law
case,
is very clear.
But petitioners retired from service without accepting any pension. He's a penniless. He's starving. The last 3
How many,
years, there is
like you, how many persons are waiting for pension before the tribunal? Do you know?
But in respect of this petition,
Therefore, that is why we are saying, why this petitioner? Why not?
I am paying that matter can be placed the next circuit bench. The next circuit bench, that matter can be placed.
No, sir. We'll consider right now. You have argued everything.
No, argued, but that in merit, I argue. Kindly allow me to merit the argument. In the merit, there is a case. Petition.
After we accept, then only merit will be argued.
Yes.
If we don't accept, where is the question of merit?
I place the judgment regarding if there is no bench. If the tribunal is non-functioning,
Come tomorrow. Learned counsel submits that he is relying on a judgment.
Monday, tomorrow, my personal difficulties,
to show that the matter will be, it should be entertained by this court at this stage when it is still pending before the tribunal.
Yeah, if their
As
petition can be
prayed-
remediless.
As prayed list on Monday. You are in both matters.
Yes, yes.
Yes, yes, Malad, both matters.
Yeah.
Malad, both, Malad.
Also go.
Question.
Oh, yeah. Next. Oh, it's over. All the appeals.
No, Lordship, actually, you suggest us to. No, no, we have. हमारा सालों का साइकिल